Mr. Forenza said something about special appearance, not a general appearance. I don't know what he was trying to say. Mr. Fitzgerald, what would you like to do today, sir? I know you're covering.
And I object to this right now. I do not consent to this hearing.
All right, I need you to stop talking or you're going to be removed from the courtroom. This is your one and only warning. You have a lawyer. He does the talking for you. We're not doing this, Mr.
I'm
Forenza.
terminating my lawyer.
Okay, we can talk about that on another day. Mr. Fitzgerald, sounds like he doesn't want to have counsel.
I can tell the court that we asked the court to bring up the question of my client's bond. He said on a $250,000 bond, and we had asked to have a reduction. Obviously, he doesn't want to see us move forward, but I do believe that I have to advise the court as to our basis for the motion.
But we also have the complication of Mr. Forenza saying that he doesn't want to have counsel. So sounds like we should probably just set this for a hearing in the not too distant future, Wednesday the 15th at 4 p.m. So Mr. Forenza, I assume someone from from one of your attorneys will be in touch with you here in the not too distant future.
I haven't heard from my attorney at all.
Okay.
That's effectiveness of counsel.
Okay.
Also, I still don't know the nature and cause of the crime. I have no probable cause, nothing, being held 97 days without nothing.
Okay.
Violation.
Sure. So Wednesday the 15th at 4 p.m. If you want to fire your attorneys, that's totally within your right. You hired them. And then you'd be automatically eligible for the public defender, given that you're in custody.
They're in conspiracy with the DA. I also have proof of that. So
okay, well, that is proof that I think would be really important to show to a number of different authorities. So Wednesday, July 15th, 4 p.m. Well, for status of counsel, perhaps bond. We'll see everyone then. Bye-bye.
Thank you, Your Honor.
All powers of attorney.
Again, I don't know what that means. In the Forenza matter, this is 26 CR 299. He's in person in custody. His lawyer, Ms. Geisinger, appears via WebEx for the moment. Ms. Geisinger, can you hear me? Ms. Bauer is here for the people. Ms. Geisinger, I can see that you unmuted yourself. Can you hear me? No, now you've muted yourself again.
I object, Your Honor.
No, you can't. Stop talking.
Article 3.
I'm not talking to you, sir. When I am done talking to your lawyer, I will find out what the next steps are. Ms. Geisinger.
I'm here, Your Honor.
Okay. Ms. Geisinger, good afternoon.
Good afternoon.
So we're here on the record in the case that I've already called. Mr. Forenza is in person in custody. He's suggested last week that he wanted to discharge you as counsel of record. You filed a motion to withdraw that you indicated was unopposed. I got it yesterday. I didn't want to grant it until I heard from Mr. Forenza specifically about that mention of it being unopposed. So I'm going to give Mr. Forenza a chance to tell me, do you object or not object to your counsel withdrawing?
I want her to withdraw.
Okay. All right. I'll go ahead and grant the request for privately retained counsel, Ms. Geisinger, to withdraw. Thank you for showing up today. See you when we see you, Ms. Geisinger.
Thank you, Your Honor. You have a great day.
You too. Bye-bye. Mr. Forenza, what do you want to do for an attorney, sir?
Oh, I have a right to represent myself.
Okay. So I've got some questions for you. We've got to go through these questions before I can decide whether you can represent yourself.
Object, because you cannot make a determination on my behalf.
Okay. So Mr. Forenza.
I'm here by limited special appearance. I don't waive any rights. I challenge jurisdiction, all jurisdiction, and I want to establish on the record before we move forward any proceedings.
Okay, Mr. Forenza.
And I preserve the record for appellant.
Mr. Forenza, do you understand that you have a right to be represented by counsel throughout these proceedings?
I understand my rights, Your Honor.
Okay. Do you understand that right, though?
I understand my rights, Your Honor.
Do you understand that right?
I understand I have a right to counsel.
Thank you. And I'm going to tell you, sir, that we can play this game. You're welcome.
Your Honor,
no, stop. Let me finish. You are welcome to do this. You can file papers about jurisdiction. You can file papers about anything you want. And I'm going to look at them. I'm going to give the DA a chance to respond, and I'm going to issue orders. That's how this is going to work. But today, right now, if I can't get through this, then I can't determine whether you can represent yourself. That's the law in the state of Colorado. Whether you agree with it or not, that's not my problem.
That's a violation of my rights.
Okay. I have a fundamental belief that I have to follow the law, and that's what I'm going to do. If you disagree,
laws or
that's
statutes,
great.
Your Honor. I'm challenging every jurisdiction. I'm challenging everything that you do.
Great.
That the DA does. I have not been. I have no nature and cause. I have no probable cause. I'm being unlawfully.
You're going to go back into the jail if you can't follow my directives. That's exactly what's going to, and we're going to keep doing this day in and day out
Article 3,
until Article 3 what?
Subsection 1, you're supposed to be.
Of what?
Of the Constitution.
Which Constitution?
Not the state. The United States Constitution.
I'm an Article 3 judge?
No, you're not Article 3. Under Article 3.
Okay. Sir, do you understand you have the right to be represented by an attorney throughout these proceedings?
I do understand.
Okay. Do you understand that if you can't afford an attorney, and because of your status as an incarcerated individual, that you automatically qualify for the appointment of court-appointed counsel? Do you understand that?
Understand.
Okay. Do you understand that I would appoint an attorney to represent you if you wanted me to? Do you understand that?
I do understand, but I do not accept, and I will challenge that.
Okay, understood. I'm going to make sure that you understand the charges that you're facing, which are up on the screen here. Do you understand that you are charged by one in a position of trust, 2 counts, both of which are class 4 felonies? Those particular charges carry with them the possibility of 2 to 6 years to life in the Department of Corrections, followed by an indeterminate period of parole. There's the possibility of those particular charges. I'm not sure if they're extraordinary risk crimes, but if they are, then Ms. Bauer?
Yes, it's 2 to 12 to life. They are extraordinary risk.
Okay, so then the possible penalties are 2 to 12 to life in the Department of Corrections. And what that means, Mr. Forenza, to break it down in somewhat more layman's terms, is if you were convicted either by plea or at trial, it would be a sentence, it could be a sentence of any number between 2 years and 12 years, and then it would be up to the remainder of your natural life. Again, Ms. Bauer, please correct me if I'm wrong, but I think that one would be 10 years to 32 years to life. No?
That is the 8 to 24.
8 to 24 to life.
Yes.
So that's also an extraordinary risk crime. These particular statutes, crimes, sir, have unique penalties in the law. So I'm trying to make sure I get it right. That's 8 to 24 to life, followed again by that indeterminate period of parole. It would be 20 years to life of parole, to be exact. So do you understand the possible penalties?
I do understand possible penalties.
Okay. You're not waiving any rights by answering these questions. You're not waiving jurisdiction. You've already objected to that. That's all on the record. Everything's recorded.
I do challenge jurisdiction.
I understand. No, you already said that. You don't have to keep repeating it. Do you have any legal training, sir? Like, have you gone to law school? Did you go to college, get some legal training in college, taken some classes?
I'm a certified law professional
A certified law professional. What does that mean?
under the Constitution and international level. I don't practice state law because of statutory codes. Rodriguez versus Ray Donovan, all statutes are unconstitutional, according to the Constitution.
Okay.
So I stay away from your statutory,
So you claim you have some legal training.
sir.
Okay. Did you go to law school?
No, I was going to apply, but I decided not to. I understand that the legalese that is used is basically doesn't make sense to our rights, and it's a whole different ballgame.
Okay.
I understand where it's derived from also too. I studied that.
Great. Did you go to college?
I have.
Where did you graduate from college?
I graduated from ITT Technical Institute, bachelor's degree,
In what?
information security cyber specialist.
Okay. So you're a high school graduate from college, have some legal training. Are you not under the influence of any alcohol, drugs, or medication that may negatively affect your ability to think clearly here today?
Well, obviously, I'm in torture cuffs and unlawfully detained, so no alcohol, no drugs.
Okay. Believe it or not, sometimes folks manage to get a hold of those things in jail, but
I don't drink. I don't do that stuff.
great. Do you want to consult with the public defender, not as an appointment, but just to talk to them?
I would be waiving my rights and giving up jurisdiction.
It would not be waiving your rights. It would not be giving up jurisdiction. It would simply be consulting with the public defender before you make this decision.
No, sir.
Okay. Do you understand that criminal law is a remarkably complicated area? That folks like Ms. Bauer have been doing this longer than I have. They've gone to law school. They've practiced law for many years. They've had to take a test, pass a bar exam. It's complicated. It's not easy. Do you understand that?
I do understand. I do understand that I'm being deprived free access to the courts and law to defend myself. And there's no resources for us here. And that's a violation. Okay. I do understand that.
Okay.
So had I have more stuff to do what I have to do and discovery and also Brady content, extrinsic, intrinsic evidence, everything, I would be able to fight my case.
Okay.
But I'm being dragged through this with nothing. So I've been unlawfully detained for 104 days now with nothing.
Okay.
You think that's fair? That's unfair trial.
Okay. So do you understand that criminal law is a complicated field?
I do understand it's complicated.
Okay. Do you understand that you have the right to confront, cross-examine witnesses, put on evidence in your own defense, demand a trial before a jury or a judge?
That's correct, and face to face.
Okay. And do you understand you have the right to subpoena witnesses to compel them to testify on your behalf or as part of your case?
That's correct, sir, but it's hard when I'm here and I have no resources to do that. So again, it's one-sided and the thumb is on the scale.
Okay. Do you understand that once you make this decision, there's a distinct possibility that there's no going back?
I do understand. I'm fighting for my right, my life and my rights.
Right. And you understand that by doing so, without counsel representing you, without the public defender, without privately retained counsel, that you take a great risk of not doing this right.
I take a great risk with counsel, and I do understand the risks involved. But
Tell me what the risks involved are.
not being provided the essential elements to the case.
Okay.
Can defend it. I have 104 days. You know what I could have done with that? I've had my property stolen by these guys. I've had money stolen, my life stolen, and this goes farther back than this from Mesa County.
Yeah.
So there's a lot more involved in this than just this. I've been stripped of my life, liberty, and property.
So going back to the consequences that you're looking at, you talked about the 104 days you spent in jail. I told you a few moments ago, if you were convicted at trial, the ultimate consequence here could be the rest of your life incarcerated.
That's correct.
And you want to run the risk of trying to represent yourself, thinking you're going to do it better than anyone else who could assist you, period.
Your Honor, this is the racketeering system here. I've talked and I've interviewed many people here, and it's the same thing with the public defenders. You put excessive bails. You just go to extreme, taking their life away. And I understand there's certain consequences. Yes, you have to do what you have to do. But I'm hearing the stories. I've learned a lot here.
Yeah.
I've learned a lot. A lot's going to be exposed.
Okay.
So what me going with an attorney is going to be no different than me doing it myself.
Okay.
I've had an attorney I paid for, and effective counsel, they don't even call me. I tell them I need this done, that done. They don't even do it.
Okay.
So how is that even worth wasting my time with?
So I don't know. I can't tell you the answer to that question. I mean, that was a privately retained attorney, whether it was privately retained or not. I don't know that I could answer the question,
With
but
defenders, Your Honor, I get them and they go behind my back and I find out I'm not going to go because I'm going to be filing on that, but stuff that happened.
okay.
This is an injustice system.
Okay.
There's no fairness here. I'm not going to have a fair trial. There's not going to be an impartial jury. I've been slandered all over the U.S., the internet. So how are you going to have a jury come in and sit now on my case? It's your duty to make sure that that doesn't happen.
Right.
It's beyond that.
Yeah.
It's beyond that.
It is my job to make sure you get a fair and impartial jury. And I will make sure that happens if and when we get to that point. It's also my job to try and advise you against making, I don't know that it's my job to advise you, but it is my job to tell you that you make a great chance of making a mistake by choosing to represent yourself. But I don't know that I'm going to be able to really impart that upon you any more than I have already done so, especially when you have as much on the line as you do. You've convinced yourself that you can do it better. So,
Your Honor, if you don't mind.
sure,
So,
I might mind. Depends.
the excessive bail.
Yeah, we're not talking about bail.
No,
and
I
I didn't set your bail, by the way. I just upheld it when we had a bail
But
hearing.
the prosecution fabricated. They didn't produce any evidence to me, submitted to me, and they used content that shouldn't even been in there, basically saying that I'm a threat to the public. Well, if this is back in 2010, 2011, I've been
Remember, you have the right to remain silent.
right, but there's nothing else. I've done nothing.
Well, I think at your bail hearing, I mentioned that there was a prior case in this courthouse, so somebody
was dismissed.
right.
Right, and it was, federal court had jurisdiction, Your Honor, and that's why Mr. Groton didn't want to accept that. So he unlawfully had me detained, okay, which is a violation. So it wasn't I didn't show up. I came there, I filed on the record with the court, and I also appeared and to verbally tell him.
And what happened when you did that?
He got mad.
Oh, he got mad.
He
Okay.
got very mad. So it wasn't like I was running and it wasn't like I was trying to just not show up. No, I was performing to the contracts and now they're dismissed. So I'm not a threat. If I could be released to go do what I have to do, I mean, my finances, my credit shot. I mean, talking about unusual punishment, this is it. It's destroyed my life, my reputation. I would just like to get out there so I can get my stuff together and do what I have to do to come in here to fight this, because there's a lot more to this than what they know.
Okay.
And my evidence has been taken from me.
All right.
There's a lot more to this than, trust me, it goes farther than this.
All right. Well, like I said, if you think you're going to be able to do it better yourself from the position that you're situated in the Mesa County Detention Facility than an attorney representing you, advocating on your behalf, then that's your choice. And I'm going to honor that request. So I'm going to find that the defendant has knowingly, intelligently, voluntarily waived his right to counsel. This is his decision alone. He has full awareness of the right that he's exercising, and he is competent and capable to at least the minimum degree to be able to litigate these matters himself. So with that being said, Mr. Forenza, this is otherwise a review hearing. So you're going to have to follow all the rules of court, all the rules of law, like Miss Bauer would. You're not going to get any breaks or benefits because of your status as a pro se defendant. What would you like to do today, sir?
Personam, pro se is
Yeah,
obviously
okay. You can put all that in writing. What would you like to do today, sir?
Well, I'd like to express the excessive bail.
Okay, we're not going to address bail on the record because we've already done it in person. There's a specific statute that allows you to demand a hearing on the issue of bail one time in person. You can file that motion and I will look at it and then we can schedule it for a hearing. So what would you like to do next?
I would like to compel the prosecution to turn over all discovery.
Very well. They have to give it to you by law. I imagine your counsel, Miss Geisinger has all of the discovery, but the prosecution has an obligation to now give it to you directly. It may be, I don't know what facilities the jail has for you to be able to watch it, look at it. Some of it, I think, I don't know. I don't know if any of it is of a nature, given the charges, that would require some further accommodations. But at least the bulk of it should be able to be transferred to the defendant. Miss Bauer, how quickly can you get it to him?
Well, there is, so can't transmit that to him. And I know that a lot of the discovery, we had been asking the defense attorney for a flash drive because it was too much to be able to just send.
Well, you're going to have to get it to him. So whether you put it on a disk, flash drive of your own, they'll be getting you your discovery and they have to do it within a prescribed period of time.
Including the Brady content, Your Honor.
Well, of course, they have to. They have to give you exculpatory information that's in their possession. Otherwise, they risk losing their right to practice law. And by they, I mean Ms. Bauer and anyone else who may handle this case. So your discovery is going to be coming. It'll be coming soon. I'm trusting that the jail has some way of inmates being able to look at discovery on a computer. So I'm seeing head shaking. Yes.
Also, Your Honor, jail is supposed to be providing any type of, you call it pro se packs. And
I don't know what that is.
it's paper, pens, resources to actually do what I have to do.
Okay. I get letters and motions from defendants all the time.
Yeah, well, writing with a pencil and this little flexible pen and stuff is hard. So,
This is what you asked for, Mr. Forenza. I don't know what you want me to give you a computer. I can't give you a computer.
I'm requesting to be released so I can fight my case.
Yeah, I told you how to go about it.
Excessive bail, which should be at least to where my financial needs could meet it. It's just, that's where I'm at. And the fact that, what they have stolen, which has nothing to do with the case, goes far and beyond this.
So I guess what I'm hearing is you want to get the discovery. You want to be able to go through it. You're contemplating perhaps filing a motion to modify your bond, and you need time to do all of this.
Yes, sir.
Okay. So we'll go ahead and set this over for how much time do you need to get him the discovery, all of it, Miss Bauer, Miss Marks, I guess?
Sounds like a couple of weeks. And I guess the question is, do we want to set it for prelim or?
He didn't ask for that. If he does, I'm happy to set it for a prelim.
Yes, sir.
Do you know what a prelim is?
Yes.
Okay, so we'll go ahead and set it for a prelim. You've already told me you know what it is, but I'm going to just tell you it's a hearing where I'm going to determine whether there's probable cause to believe that you've committed the offenses at issue. That would be all of them because they're felonies and you're in custody. Your previous attorney waived your right to have it within 35 days, so I don't have to set it within 35 days, but I imagine you probably don't want it set that quickly because you want to at least have a chance to look at the evidence before you can.
Yes, please.
Okay. Yes, please, what?
I'm sorry. I would like to see what.
Yeah. So I'm going to give you a little bit of time. And then if technically you don't have a right to discovery before the hearing in the first place, but I'm going to do my best to accommodate this so you can have a chance to go through as much of it as humanly possible and present your case. We're going to come back sooner than that, Mr. Forenza, just to make sure that we're moving along and you got your discovery. Okay, so September 8th at 8:15 will be your preliminary hearing to 9 a.m. We'll come back, let's say a few weeks before, August 20th. It's been a month away, 8:15. Like I said, if you file that motion to modify your bond in writing, subject to the statute that I've alluded to, we could end up moving that August 20th date up sooner for that hearing. Anything else, Mr. Forenza?
No, Your Honor.
Okay. Mr. Forenza, I said you may not, there may very well be no going back in terms of your decision to represent yourself. I want to see you have the best chance here, sir. I don't have a dog in this fight, whether you believe that or not. I don't care.
I understand you're there to.
But my goal is to make this as fair as possible for all involved. You have a ton of rights. You have this basket of rights, and you can compromise your ability to exercise those rights if you don't know how to use them correctly. A lawyer could help you. That's all I'll say. So when I said, once you go down this road, you may not be able to go back. The further and further down this road we go, the less and less likely it becomes that I'll be entertaining a motion or a suggestion from you. Judge, I realize I've gotten in too deep. I don't want to spend the rest of my life in prison because I made some terrible choices about not getting a lawyer, this, that, or the other thing. Can you please appoint a lawyer? Please give me a second chance. I just know that.
Your Honor, my experiences with 5 lawyers have done absolutely nothing for me but drain my money.
Okay, well, I don't know if you've had public defenders before. They know what they're doing. They're excellent attorneys. That's all they do. I understand you may think there's a conspiracy between them and the prosecution and maybe the court. I don't know. I told you the other day, if you have such evidence, there are some folks who would be really interested in looking at it. If you're just saying that to say it, then there's no harm, zero harm.
This is why they went.
There's zero harm in having a public defender come and meet with you, talk to them. If you don't like them, you want to continue down this path, it's your right. I've already made the decision. You can represent yourself. But perhaps you meet with them and you decide, whoa, these people do actually know what they're doing. They're going to fight harder for me than anyone else. And I need to kind of reverse course. We can talk about that too. It's your choice. You've made your decision for now, and I've granted your request. Like I said, the further down the road we get, the less likely it becomes that I'm going to let you reverse course again. We'll see you on August 20th at 8:15. We're adjourned.